Hello and welcome. This is Jeremy from Legal Studies Advantage. In this brief video, I'd like to provide for you an overview of the subject of contract law. Number 1. Introduction. For our purposes, the letter K will be our shorthand for the word contract in our written materials. Most of law school contract law follows a story where someone, a plaintiff, sues another person, a defendant, claiming that they breached a contract and either owe them what was required under the contract or money to compensate for the failure to perform as required by the contract. The plaintiff, the injured party, will have to prove that there was a valid contract in place and that the defendant did not perform as required. The defendant will have to prove there was no such contract or that there is a valid defense against performing, which excused the breach of the defendant. Remember, the plaintiff will seek remedies and the defendant will raise defenses. Contract categories. Two of the most important types of contracts are common law contracts, such as real estate or services contracts, and UCC contracts for the sale of goods. The acronym UCC stands for the Uniform Commercial Code, which has been adopted in most states as part of their contract law. Some legal rules are different for common law versus UCC contracts, and those differences will be important to note in law school. Number 2. Does a contract actually exist? A valid contract enforceable against a breaching party exists where the following requirements are met. One party offers terms of an agreement, the other party accepts those terms, and adequate consideration is provided. Now, what is consideration? Consideration essentially is a legal demonstration of a party's seriousness about entering into the agreement that will impose duties upon them. Such duties may include the duty to pay, to provide goods, or to provide services, and so forth. Consideration usually comes in the form of making their own promise to act or providing some value in exchange for a promise to act or value from the other party. Number 3. Were the terms of the contract breached? The plaintiff must prove what the terms of the contract were and what performance was required thereunder. The plaintiff must also prove that the terms were not performed, that there was in fact a breach by the defendant. One important rule that will come up in this area of contract law is the parole evidence rule. Generally, the terms of a later contract take precedence over evidence of different terms from before the final contract was consummated. Additionally, the Uniform Commercial Code, the UCC, can help fill in some missing terms for sparse UCC contracts, in other words, contracts for the sale of goods where all of the terms weren't specifically and completely addressed in the contract terms itself. That statutory scheme, the UCC, sometimes fills in the gap for contracts that are not complete. Number 4. How can a defendant defend himself? If a defendant failed to perform as the contract required, in other words, if the defendant breached the contract, the defendant may yet be able to avoid civil liability by offering some excuse for non-performance or some defense against enforcement of the contract. One such defense is a violation of the statute of frauds. In other words, the defendant may raise this defense and say there was a violation of the statute, therefore I'm not liable for the contract. Some really important kinds of contracts are only enforceable if they are both written and signed, as required by the statute of frauds. If the defendant can show that the breached contract was one of those kinds of contracts, and that it was not written and signed by the defendant, then the defendant is basically saying, look, I'm off the hook, and the contract cannot be enforced against the defendant. There are many other important defenses the defendant might be able to raise to avoid liability to a plaintiff. Number 5. If the defendant loses, what damages or remedies can the plaintiff get? If there's a valid contract between the plaintiff and the defendant breached its terms, and the defendant has no legitimate defenses, then the defendant is going to lose. The plaintiff will get some form of remedy, money, or some court-compelled performance, and so forth. Legal remedies. These are sometimes referred to as money damages. This is money that the court determines must be paid by a defendant to a plaintiff to make up for various types of losses associated with the defendant's breach of the contract. Equitable remedies. In some cases, the court can compel certain actions, such as performing what the contract actually originally required, or it can alter, cancel, or impose other contract terms to right wrongs to the plaintiff. Let's give a brief illustrative example of a contract case. Annie says to Bob, I promise to pay you $50 if you promise to paint my front door next week. Bob verbally accepts Annie's offer. There is a valid contract. Why? Because there is offer, acceptance, and consideration. And as a result, both parties now have duties to perform. Annie must pay, Bob must paint. If either party fails to perform, there is a breach, and the non-breaching party may bring suit to enforce the contract. The breaching party may try to raise a defense to excuse their breach and to avoid liability under the contract. If there is no valid defense, a court may impose payment or performance obligations against the breacher as a remedy. That concludes our brief introduction to the subject of contract law. Please visit our website at www.1lsuccess.com or www.legalstudiesadvantage.com for more information about how our 1L Success package can help you to succeed in law school. Again, that's www.1lsuccess.com with the number 1 or www.legalstudiesadvantage.com. Legal Studies Advantage LLC, reinventing legal education.